may be seated. Thank you.
Petitioner can proceed.
If the participants are now ready, I would call upon the petitioners to proceed. Pardon me.
Mr. Chief Justice, and may it please the Court. My name is Joshua DeFord, and I represent the petitioner, Cynthia H. Petitioner respectfully requests that this Court overturn the South Virginia Supreme Court decision for two principal reasons. First, because the Defense of Marriage Act is not a proper exercise of Congress's power under the Effects Clause, and because the South Virginia Supreme Court's decision not to enforce the valid divorce decree of the Massachusetts Court violates the Full Faith and Credit Clause. And second, because the Defense of Marriage Act and the Marriage Protection Act violate petitioner's fundamental right to marry the person of her choosing, regardless of sex. And as an infringement upon a fundamental right, they must pass strict scrutiny, which they fail. Now, before I get into my first point, may I reserve 2 minutes for rebuttal?
You may.
Thank you, Your Honor. Now, regarding that first point, and which would be the more narrow grounds on which this Court could hold, is that the valid judgment of the Massachusetts Court cannot simply be disregarded by the South Virginia Supreme Court. And this Court has held in Baker v. GMC that although there are some public policy exceptions to the enforcement of sister state statutes, the enforcement of judgments, that with regard to the enforcement of judgments, the full faith and credit requirement is exacting. And that's regardless of whether or not the forum state, the state in which the judgment is sought to be enforced, would have granted that judgment in the first place.
But isn't this different because Congress has enacted the Defense of Marriage Act, specifically claiming to have the power under the second sentence of the clause?
Well, that would get to my second point under that first argument, Your Honor, and that is that the Defense of Marriage Act is not a proper exercise of that power. Now, the first phrase of the Full Faith and Credit Clause actually says that states shall give full faith and credit to sister state judgments. And to read the second clause to give that broad-reaching power would more or less nullify the first statement. And I would analogize
So it's your position that shall means shall.
Excuse me, Your Honor?
It is your position that shall means shall. In other words, it is mandatory. Have to give full faith and credit.
Yes, Your Honor. Now, this
How
Court...
do you explain the distinction we've always made between judgments on the one hand and acts and records on the other?
Well, I would say that this Court has acknowledged a public policy exception for statutes. And so this Court is tasked with constitutional interpretation as far back as Marbury versus Madison. But what I propose that the respondents reading that second clause would do would impermissibly vest that power within Congress. And moreover, Your Honor, to take an entire class of judgments from without the reach of that first clause would be inconsistent with the purpose.
May I ask about the purpose in that respect? Is it possible that the framers, when they wanted to give the Congress this ability to judge the effect or to have an impact on the effect of a judgment, is it possible that they would have foreseen that there would be certain kinds of issues that would be so divisive to the country that they would want to promote the unity of the country and the Federalist approach and not require, and so with legislation literally say, in these kinds of ultra-divisive situations, you're not going to have to give effect to even those things that you confess were factually understood appropriately, but we don't want to cause such deep offense to a jurisdiction that it would impair its sort of desire to be a part of the federal system. Couldn't that have been a consideration?
It could, Your Honor, but I would respond with 2 points. The first being that this interpretation of the effects clause goes against that purpose of unifying the states and promoting comity between the states, because it actually allows states to disregard an entire class of judgments. It does not promote that particular interest, Your Honor. And second,
From which sources are you drawing this purpose?
excuse me, Your Honor?
From which sources are you drawing this purpose?
I was merely responding to Justice Ashcroft's question, positing if that could perhaps be the purpose. But there is that purpose expressed in the Federalist Papers. Specifically, James Madison proposed that was the purpose. But getting to the second point.
Didn't the Articles of Confederation include a full faith and credit clause?
They did, Your Honor.
And wasn't it pretty much just what was written in the first sentence of Article 4, Section 1?
That is correct, Your Honor. However, this court has interpreted the first clause of the Constitution as requiring full faith and credit. Again, getting back to Baker versus GMC, and again in Fauntleroy v. Lum. And what Fauntleroy v. Lum said, to give the court background on that case, it was a Missouri judgment based on a contract and speculation of cotton futures. And that judgment was held to be enforceable in Massachusetts, and indeed, in Mississippi. And indeed, Mississippi was required to enforce that judgment, despite the fact that the contract would have been void in Mississippi, and despite the fact that Mississippi public policy would have gone against granting that judgment.
Can you distinguish Fall v. Easton then?
Well, Your Honor, again, this is about the public policy exception to judgments. And if there were a public policy exception to be recognized, it would be by this court, and it would be this court's jurisdiction to do that. And again, this would not be the set of facts on which this court should do it. This case instead should be governed by the Kidnapping Act.
Well, it's similar to Fall in that in Fall it was a piece of property located in the forum state. Here the child is now located in the forum state. So why shouldn't South Virginia be able to adjudicate the visitation rights to that child?
Well, the distinction between a property right and passing title to land and the agreement here is the difference between in rem jurisdiction and in personam jurisdiction. Now, there is one of the requirements of the full faith and credit clause is that the home court, in this case Massachusetts, would have to have jurisdiction over the parties or the matter and the subject matter. Now, in the passing of the title to land, that would be in rem jurisdiction, and a home state could not impose its in rem jurisdiction over land located in another state. However, here, Your Honor, Massachusetts had jurisdiction over both of the parties, and so both of the parties are bound by the agreement. And again, if there were a situation in which a public policy exception would be recognized for judgments, it should not be this case, because in this case, the Massachusetts order was validly entered, and the respondent intentionally left the state in order to avoid that jurisdiction and in order to avoid the requirements of that judgment. And judgments, divorce decrees have been considered judgments under the full faith and credit clause, both in Williams versus North Carolina, in which case a divorce decree was entered in Nevada. That same divorce decree would not have been able to have issued in North Carolina, but this court said that judgment must be recognized, that the Nevada divorce decree had to be recognized by the North Carolina court.
Is another way of saying recognize a judgment to say the state must give effect to that judgment?
No, Your Honor. It must enforce that judgment, Your Honor.
Enforce that judgment. In other words, give it the legally binding effect the judgment normally has.
The same effect that it would have in the home state, yes, Your Honor.
Right.
When the framers of the Constitution borrowed the phrases full faith and credit from the Articles of Confederation, didn't they simply mean to give it evidentiary effect that it was what it purported to do? And isn't the evidence of that the fact that they added the second sentence, which allowed Congress to determine what effect should be given?
Well, I would point the court first to the full faith and credit statute, which is the implementing legislation. And that echoes the same language. And yet that has been held to require the same full faith and credit in the home state as the I see that Your Honor has another question.
In modern jurisprudence, it has. But if you look at the early circuit court decisions where a Supreme Court justice and two circuit judges were construing it, they always, once they said that these judgments were final, relied principally on the combination of the Constitution and the Act of 1790. Is that not correct?
Well, Your Honor, whether or not that would be the case, and I would grant you that point. However, this particular issue has not been before the court as to whether or not the effects clause grants Congress the power to completely nullify that first clause. And
yet you argue that it's conclusive in your mind that Congress did not have the power.
That what is conclusive? I
That
apologize.
Congress did not have the power to nullify or to exempt this area of judgments from the ambit of full faith and credit.
I would say that is correct, Your Honor, because I would analogize again to Section 5 of the 14th Amendment. Now, Section 5 of the 14th Amendment says that Congress can pass implementing legislation to implement the amendment. However, this court held in City of Bernie versus Flores that it cannot redefine the scope of the right under the 14th Amendment, that it cannot essentially nullify the 14th Amendment. And Petitioner's position is that is what the effects clause grants to Congress, a procedural power to say how these judgments should be enforced, but not to nullify an entire class of judgments as was done here in Doma.
Go ahead.
Well, thank you. Well, you mentioned James Madison a few moments ago and the drafting of the effects clause. Didn't he also say that the effects clause is extremely indeterminate and can be of little importance under any interpretation which it will bear? Didn't he mean there simply that the effects clause gave power to Congress to establish justice between the sister states, and its meaning would become evident over time? And it's not the broad limitation as you're prescribing.
First, to say that the effects clause was meaningless cuts the other way, Your Honor, because it would show that they don't have this broad power under the effects clause to nullify the first part. Now, about the
But what did he mean by extremely indeterminate? Those were his words. And he's the author of the effects clause because it wasn't in the Articles of Confederation.
Well, to say that it was an indeterminate would be perhaps to say that, and again, I can only speculate as to what Madison meant in that particular phrase, but to say that it was indeterminate could have meant that as any power vested in Congress is indeterminate because no law has been passed under that power. So, but again, to say that it's indeterminate and limited would cut in favor of my argument.
No, but I was saying it's indeterminate in that Congress uses it when it needs to step in to allow nonconformity because nonconformity promotes the Union more than conformity because South Virginia would be upset if it's forced to accept the social policy of Massachusetts.
Well, again, Your Honor, deciding that the effects clause in this case means that the Congress can say no effect to this class of judgments would actually cut the other way because it would allow South Virginia to rob Massachusetts of its authority. In other words, Respondent in this case would be able to leave Massachusetts and escape the authority of a judgment and escape that even though it was a validly entered judgment with jurisdiction simply by moving to South Virginia.
Wouldn't Respondent always have recourse to the courts of Massachusetts?
Respondent would have recourse, exactly, Your Honor, but what Respondent has chosen to do here is leave the jurisdiction. And in this case, it simply does not make sense.
Wouldn't Petitioner always have recourse to the court in Massachusetts for a contempt order?
Well, that's true, Your Honor, but again, with Respondent moving to South Virginia, there's a need there to have the South Virginia court enforce that judgment. And that's what Petitioner has done here, has a valid judgment and attempted to have that enforced in South Virginia.
How are sister state judgments treated under the full faith and effects clause of full faith and credit clause of the Articles of Confederation?
To be honest, Your Honor, I don't have a lot of case law on that, but there is some indication that they were not given the full effect of needing to be executed. That is true, Your Honor.
Wouldn't that support the point that the bulk of the work of the clause was meant to be done by the second sentence, the effects clause? In other words, the first, what the drafters saw was that the clause we had in the Articles of Confederation really wasn't accomplishing much. We need a clause that actually does something. We'll give Congress the power to determine the effects of the records, acts, and proceedings of sister states.
I would again say that that's not the understanding that this court has enunciated throughout the years.
Well, we could always be wrong.
Yes, Your Honor.
We won't admit it, but we could always be wrong.
However, relying again on this court's interpretation of both the full faith and credit clause, there is a requirement that judgments be enforced.
What do you think then is the point of the second sentence?
Excuse me, Your Honor?
What do you think is the point of the second sentence?
That would be, again, a procedural power first to say how these judgments should be enforced. A good example is the Kidnapping Act, which says that parental custody or visitation orders, like the one at issue here, shall be enforced without modification. And so in that case, Your Honor, they have said that they will be enforced with the exact terms that were given by the home state. And what it certainly does not mean is that Congress can effectively amend the Constitution with a majority of Congress and change the entire meaning of that first clause.
May I suggest that you move to the due process argument? I don't want for us to preclude your focus on another important aspect of your
Thank you, Your Honor. And if the court were to reject Petitioner's first argument under full faith and credit, it would run headlong into the issue of same-sex marriage. It would run headlong and would have to decide whether there's a fundamental right to same-sex marriage, which Petitioner argues that there is such a right. If you look at the case of Loving v. Virginia, that's very instructive. And it actually, in that case, it was a law in Virginia that banned interracial marriage. And what this court said was that there was a fundamental right to marry. And what this court said was that decision on who to marry was one of the most intimate decisions that a person can make.
But our states have regulated marriage for generations in terms of relatives not being allowed to marry, individuals under a certain age not being allowed to marry, laws against polygamy. Are those laws unconstitutional based on your argument?
No, Your Honor. And I would first point to the fact that in Loving v. Virginia, the state, in trying to uphold the ban on interracial marriage, actually brought up that same parade of horribles at oral argument. And obviously, this court did not accept that. And those would be different situations that would have different interests in mind. But what Loving stands for is that the fundamental right to marry is the fundamental right to marry a person of your choosing, whether or not that person is of the same sex or of a different race. And this court has
interracial marriages were known to the founders. I mean, it was an uncommon thing, but it did happen. This is something that was clearly not within the contemplation of those who wrote the Constitution and founded this nation.
I would again point the court to Loving v. Virginia. And in that decision, this court actually acknowledged that some members of the 39th Congress that drafted the 14th Amendment may not have seen interracial marriage as protected under that amendment. But nonetheless, it said that there was a fundamental right to that interest. And it said that despite that fact, this fundamental right needs to be extended to all those, and it cannot be taken away as a basis of discrimination.
What is marriage?
Well, Your Honor, again, there's a dictionary definition, but then there's the definition that this court has given it. And
What's the dictionary definition?
I don't have a citation for that, but I think that the point that Your Honor is getting to is that a dictionary may define it as a man and a woman. However, this...
Well, no, I think it's a little... What I'm getting to, I think, what I'm trying to explore is a little bit deeper point. I mean, what is it about marriage that makes it amenable to include couples, including couples composed of members of the same sex, or what is it about marriage that excludes members of the same sex? In other words, what's the special characteristic of marriage? It seems to me that's what this case boils down to.
Well, I would look to Griswold first off, and then also that says that marriage is one of the decision to enter into a marriage is one of the most intimate decisions that a person can make. It is one of the most intimate relationships that a person can have. I would also point to Justice Stevens' dissent in Bowers, which was later adopted by the majority of this court in Lawrence, which said that we protect the family not because of a preference for stereotypical families, but because it is so dear a decision and it is so dear to the privacy interests of the person involved.
But in Lawrence, we went to some length to state that this wasn't a statement of approval of same-gender marriages.
Well, I see that I'm out of time, Your Honor. May I briefly finish or answer the question?
Yes. Try to limit your answer, but you have about 30 seconds.
Certainly, Your Honor.
It was a short question. Make it a short answer.
Certainly, I'll do my best. What the court said in Lawrence, what it properly did was it made a limited ruling based on the facts before it. The issue of same-sex marriage was not properly before it, so it limited its decision based on those facts. I'm asking the court to similarly do that here. Thank you.
We'd be pleased to hear from the respondent at this time.
Mr. Chief Justice Ashcroft, may it please the court. My name is Stephen Barry, and on behalf of Team B, I represent the respondent, Hilda N., in this matter. Your Honors, the respondent respectfully asks that this court affirm the decision of the Supreme Court of South Virginia for two reasons. First, because South Virginia's actions were lawful under DOMA, which prescribes the effect of interstate judgments arising out of same-sex marriages pursuant to Congress's power under Article 4, Section 1 of the United States Constitution. And second, because neither DOMA nor South Virginia's Marriage Protection Act infringe on any fundamental liberty, and instead are valid as rationally related to the government's legitimate interests in fostering procreation and child welfare in the context of marriage. On the first point, Your Honors, the purpose of the full faith and credit clause as provided by this court in Milwaukee County was to alter the status of the several states as independent sovereigns and to make them part of one integral union. But indeed, Your Honor, the court recognized as early as McElmoyle in 1839 that it is the power of Congress under the full faith and credit clause to declare what shall be the effect of a judgment in one state in the state court of another state of the Union. Indeed, Your Honor, the full faith and credit clause, when read collectively, consisting of the first sentence and the second sentence, is a recognition of the reality of our federalist system, that indeed at constant tension are the interests of national unity on the one hand and state autonomy on the other.
What about Petitioner's argument that if we acknowledge that Congress has this power under the second sentence of the clause, it wipes out the first sentence?
It most certainly does not, Your Honor. And Petitioner seems to argue in this case that because Congress has arguably prescribed a non-effect of the judgment of one state when it arises out of a same-sex marriage in another state, that is somehow an annihilation. But, Your Honor, I think a helpful analogy can be drawn to recent jurisprudence when examining Congress's actions under the Commerce Power. Under the Commerce Power, Congress is vested with the exclusive authority to regulate commerce among the several states. Implicit in that power is a prohibition on the states from enacting legislation that would burden interstate commerce. This is known as the Dormant Commerce Clause. However, this court recognized in Wyoming v. Oklahoma that when Congress makes its intent clear, it may in fact authorize and lend legitimacy to state conduct or state statutes, more specifically, that would otherwise violate the Dormant Commerce Clause.
What is the floor to the effects clause? What can Congress not do?
Well, Your Honor, as it was pointed out by the bench, originally the understanding of full faith and full credit was an evidentiary meaning. Now, that understanding in this court's jurisprudence has evolved over time, and indeed recently in Baker v. GMC, this court recognized that full faith and credit is demanding, and that indeed the judgment of one state must be given a res judicata, in other words, a claim preclusive and an issue preclusive effect. So to answer your question directly, Justice Whitney, what would violate the floor of the effect clause would be if Congress said that the state, one state did not have to give claim preclusive or issue preclusive effect to the judgment of another state, or even to go even further and say that it did not have to give it evidentiary value,
Isn't that precisely what South Virginia is doing here?
I'm sorry, Your Honor.
Isn't that what South Virginia is doing here? Just not giving any preclusive effect to the Massachusetts judgment?
Not at all, Your Honor. In fact, this matter has not been relitigated in the South Virginia courts in the sense that South Virginia has started anew. South Virginia can very well recognize that this issue has been litigated in the Massachusetts courts, but not necessarily give the judgment the effect that Petitioner seeks. And indeed, even in Baker v. GMC, which Petitioner mentions, this court did recognize, again, that judgments are exacting, and that has long been part of this court's jurisprudence as far back as Fauntleroy and Magnolia Petroleum, that the judgment of one state has to be recognized. But the court made an important distinction between recognizing the judgment and giving it claim preclusive and issue preclusive effect and adopting the enforcement mechanisms contained in that judgment. And the court expressly stated that the enforcement mechanisms do not travel from the issuing state to the enforcing state. So even in that case, Your Honor, which contains some of the strongest language seemingly in Petitioner's favor regarding no roving public policy and the exacting nature of judgments, makes clear that there's a difference between honoring the judgment, giving it full faith, giving it full credit, and enforcing the judgment.
What do we mean by enforcement mechanisms?
Well, for example, Your Honor, were State A to enter a judgment that gave damages to a particular party, and that party sought enforcement of that judgment in another state, State B could very well enforce that monetary judgment in a number of ways. It could attach wages, it could attach property, even if the issuing state, if State A had prescribed a particular enforcement mechanism. Now,
Well, it doesn't seem to me here that the issue is enforcement mechanism. It seems to me that here the issue is enforcement simpliciter. They're not saying we're not going to enforce the judgment the same way Massachusetts would. We're just not going to enforce the judgment at all.
Well, conceitedly, Your Honor, there are only so many ways that a child visitation order can be enforced. A state can't be as creative as perhaps it can when enforcing a monetary judgment. But Respondent offers that point simply to suggest that the court has recognized that there is a distinction, that enforcement, at least by the terms of the original judgment.
Well, there's only one mode of enforcing an order like this, which is to allow the visitation.
Indeed, Your Honor.
So to say that we can't import the enforcement mechanism is to say you don't have to enforce the judgment.
Your Honor, Justice
you don't have to give the
Tuskey,
judgment any effect.
I'm sorry, Justice Tuskey, I raised the point simply to suggest that there is a distinction, but perhaps the more critical distinction when we're talking about Baker and Fauntleroy and Magnolia Petroleum and the whole lineage of cases dealing with the full faith and credit clause is that in those cases, Congress had not spoken. Congress had not exercised its effects clause power. In this case, Congress has spoken. Congress has prescribed the effect that a judgment arising out of a same-sex marriage in one state shall have in another state. And simply, Your Honors, the Respondent would point out that really the effect of DOMA, which is a valid exercise under the effects clause, is to reserve to the states the domain of domestic affairs and social relations and family law that this court has long recognized belongs to the states. As long back as Maynard v. Hill in 1888, this court recognized that marriage, having more to do with the civilization and morals of a people than any other institution, belongs to the legislature. And more recently in Rose v. Rose in 1989, that the whole domain of family relations between parent and child, between husband and wife, belongs to the laws of the states and not to the federal government.
Assuming we agree with your argument about full faith and credit, why does DOMA not violate the Due Process Clause?
Your Honor, DOMA does not violate the Due Process Clause because even if, as petitioner suggests, it infringes on the right of a person to enter a same-sex marriage, this court has expressly rejected the notion that there is a fundamental right to same-sex marriage. Respondent would point out that this
Where have we expressly rejected that notion?
In Baker v. Nelson, Your Honor, there was an appeal from the Minnesota Supreme Court which had denied a claim that it violated the petitioner's fundamental right to same-sex marriage. That case was appealed to the Supreme Court, which denied hearing oral argument on that case for lack of significant federal question, which in that time, as the court is aware, operated as a decision on the merits. And the court effectively said that there was no fundamental right. Now, it's telling that that decision in 1972 came only 5 years after Loving v. Virginia, which petitioner proffers recognized a general fundamental right to marriage. But indeed, the court had its opportunity to decide that issue, to decide whether the fundamental right to marry included in its gamut of marriage rights the right of homosexuals to marry, and it expressly rejected that notion on the merits. Your Honor, the Respondent would encourage the court to not proceed to go against its existing jurisprudence in Baker and to find that there is a fundamental right. Because as this court recognized in Washington v. Glucksberg, a fundamental right is one that, objectively speaking, is deeply rooted in this nation's history and tradition. And plainly, a right to same-sex marriage is in no way deeply rooted in this nation's history.
Well, neither is a right to abortion, yet we've recognized that.
Well, Your Honor, the right to abortion was included in the right to privacy, which has long been recognized by this court. In other words, the court said that the right to privacy, which had already existed and long been recognized, included.
It's been recognized since 1965 or 66 in Griswold.
The right to privacy, Your Honor?
Yes.
Well, and that may be true by that term, by the phrase right to privacy, but the right of an individual to non-government intrusion into its private affairs has long been a policy embraced and upheld by this court. So while perhaps only first articulated as the right to privacy in Griswold, it is indeed deeply embedded in this nation's history and tradition. On the other hand, Your Honor, contrary to petitioner's contention, the right to privacy has not been long recognized. And as a matter of policy, this court stated in Washington v. Glucksberg that the court should proceed with the utmost caution when considering whether to declare a new fundamental right. And the reason being, by this court's terms, is that when it does so, when it declares a new fundamental right, it effectively removes that issue from the sphere of public debate and legislative action and puts it into the hands of the judges. The 11th Circuit recognized in Williams v. Attorney General of Alabama that judicial restraint is perhaps most essential and most necessary in the area of morals legislation and in the areas of the law that are traditionally reserved to the states. And Respondent would simply re-emphasize that family law and domestic relations have long been recognized to be best governed and legislated by the states. Furthermore, this court has recognized a distinction, again, even in its Commerce Clause power, and I draw the distinction only because there's far more jurisprudence in that area, between issues of national concern and issues of local concern. In Lopez, that issue came up. And the court recognized that issues of national concern may very well be subject to national uniformity, whereas issues of local concern should be governed by the local government. Now, the state legislatures are certainly best positioned to respond to and to legislate according to the interests of their communities, particularly in the area of
Why are sodomy and abortion matters of national concern, while same-sex marriage and euthanasia are matters of local concern?
The distinction, Your Honor, is that those are private matters. Sodomy takes place behind closed doors, although Respondent would point out that in Lawrence, the court did not go so far as to declare the right to consensual homosexual a fundamental right. In fact, it applied rational basis review, so that's not applicable.
Well, yeah, we applied rational basis review and said there can be no rational reason whatsoever to criminalize sodomy, which seems to me more akin to saying this is some kind of super fundamental right.
On the contrary, Your Honor, it applies rational basis, Justice Scalia pointed out in his consent, because it did not recognize the fundamental right. The more important distinction that Respondent would make between abortion and the right to sodomy is that those are private matters, and they fall under the realm of privacy, whereas marriage is very much a public institution.
How about abortion and euthanasia?
Your Honor, those have been, at least in this court's jurisprudence, under the umbrella of privacy. But that's completely distinguishable from marriage, which is, by its very definition, a government-sanctioned institution. Indeed, the most important, perhaps, of government-sanctioned institutions. And there are very compelling government interests.
What is marriage? I mean, that's the same question I asked your opponent. What is marriage? What is it about marriage that, by its very nature, makes it limited to mixed-sex couples?
Your Honor, as far back as Blackstone, in Blackstone's commentaries, Blackstone stated that marriage is a legal union between one man and one woman. Now, interestingly, there's no reference in that.
Well, you've just answered my question, with a tautology. Marriage is what it is, or marriage is what we've called it. Why is that? Why does it have to be that way?
The reason, Your Honor, goes to the government's interests that are at stake here, that are compelling and most certainly rational. And those are twofold. The government has a compelling interest in encouraging and in incentivizing both procreation and child rearing in the context of marriage. Now, again, to reemphasize, marriage is a publicly recognized government-sanctioned institution that the United States Government Accountability Office recognized in a 2004 study extends over 1,200 rights that are unique to marriage. In other words, Your Honors, there's an incentive for two individuals to enter the marriage because they will acquire these 1,200 rights. And the state has an interest in procreation simply because, as the court recognized.
Then why do we allow the 95-year-old woman to marry the 96-year-old man?
Well, Your Honor,
unless they're Abraham and Sarah, nothing's going to happen.
Well, Your Honor, respectfully, there doesn't need to be a perfect fit between the incentive and the government interest. And in this case, there's absolutely incentive for two heterosexuals. And then the respondent does not deny. The respondent concedes that there are married couples that are incapable of
Are those people really married?
Yes, they are,
In
Your
the
Honor.
metaphysical sense, are they really married?
Well, Your Honor, the respondent would concede that this is not about a metaphysical issue. This is about a legal issue, and this is about the government-sanctioned institution of marriage and the rights arising therefrom.
If you're denying people entry into an institution that they're fully capable of entering into, and that you're allowing other folks who are not fulfilling what you say is the reason we recognize this institution are also being entered into, isn't there something fundamentally wrong with that?
There's not, Justice Tuskey, simply because homosexuals, while the respondent makes no statement about their capability to necessarily be effective parents, that they may very well be homosexuals who are fully capable of being great parents. But the reality is that homosexuals, by their definition, are incapable of procreating. And this court has recognized in Michael H. v. Gerald D. in 1989, discussed the concept that the best household setting in which a child can be brought up is one consisting of one husband and one wife. And so simply, Your Honor, this case is not about...
If South Virginia really believes that and really believes that's a compelling interest, why does South Virginia allow reproductive technologies to be used by single people, homosexual couples, and anybody else who wants to use them?
Well, Your Honor, this case is not about what the government is withholding. It's more about the actual government-sanctioned institution and the incentives that it provides in order to further the legitimate and arguably compelling government interests. And again, at a minimum, if this court does not go so far as to find a fundamental right to same-sex marriage, then DOMA and South Virginia's Marriage Protection Act are subject to mere rational review basis. Now, this court said in Caroline Products that all the statute has to do to pass rational basis muster is have a rational relationship to a legitimate government interest. In FCC v. Beach Community...
Is it rational to say we want to encourage procreation within marriage, and on the other hand, let any single woman whom the fancy strikes walk to a sperm bank and get herself impregnated?
I'm not sure I understand your question, Justice Tuskey.
No, is it rational on the one hand to say we want to encourage procreation within marriage because that's the institution in which child rearing is best done, and on the other hand, let any single woman become impregnated by in vitro fertilization, artificial insemination, or any other technology that's available to her?
There's separate
with
issues.
No intention of being married.
There's separate issues, Your Honor. Whether or not technology allows homosexuals to physically give birth to a child is immaterial to the government's interest to incentivize. In other words, that doesn't in any way weaken the government's interest in incentivizing procreation and child rearing in the context of marriage, nor does it offend that institution in any way. So I think they're very much distinguishable, separate interests that do not overlap. But fundamentally, the government does indeed have a legitimate interest in simply furthering our society, if you will, via procreation, but also recognizing that the most effective kind of child rearing is going to take place within the context of marriage. So, Your Honor, the rational relationship is clear, and as this court held in FCC v. Beach Communications, as long as there are, quote, plausible reasons for passing the statute, then judicial inquiry is at an end.
But there are theoretical reasons. Is there any empirical evidence that a child can't be adequately raised in a home of a same-gender couple?
Your Honor, there is a fair body of empirical evidence that discusses that very question. I would direct the court to a body of scholarship by an individual named Lynn Wardle, who has written extensively on the topic. Now, it would be perhaps futile to...
Of course, he's a law professor, not a social scientist.
Certainly, Your Honor, but having written on this issue, he's consulted and compiled a fairly substantial body of the research on that issue. But again, this court said in Michael H. v. Gerald D. in 1989 that a household consisting of one man and one woman is indeed the most stable context in which a child can be raised. But fundamentally, Your Honors, at the end of the day, this case is a case about judicial restraint and instead recognizing Congress's judgment that this is an area best left to the states. It's consistent with this court's jurisprudence in Maynard v. Hill, in Rose v. Rose, and that is all that Congress has done in exercising its effects clause power here. is to legislate in such a way that it prescribes the effect of a judgment of one state in another state when that judgment arises out of the same-sex marriage. In doing so, Your Honor, the respondent encourages and urges this court to exercise judicial restraint, to leave it to the legislature, to not grant by judicial decree that which could not be gained by political consensus, and instead to leave this issue in the hands of the states and in the hands of the voters, who will let this court know when they want to recognize that right. If I may just conclude.
I think you've concluded. Thank you.
Thank you, Your Honors.
The court is pleased to recognize petitioners for the remaining 2 minutes from their argument.
Thank you, Your Honor. Respondent mentioned the differences between the mechanisms of enforcement and actual enforcement, and it's true that there is a distinction, that the mechanisms of enforcement do not travel across state lines with the judgments. But as Justice Tusky pointed out, what that doesn't mean is it doesn't mean that a sister state court can choose not to enforce. Now, the mechanisms of enforcement would be the time in which the judgment may be enforced. But what the court in South Virginia did was it decided not to enforce, and indeed not even to recognize in any way, the judgment of the Massachusetts probate court. And under the full faith and credit clause, that's a clear violation of this court's jurisprudence. Moreover, the respondent mentioned that moral legislation was within the ambit of the state, but that's directly contradicted by this court's holding in Lawrence. And what this court said in Lawrence was that moral approbation is not even a legitimate interest under the rational basis standard of review. So to say that moral approbation is within the ambit of the states is directly against this court's constitutional jurisprudence. And indeed, Justice Scalia's dissent actually noted that under the majority's holding in Lawrence, same-sex marriage bans could not be upheld under constitutional scrutiny. And what Petitioner asked this court to do is recognize that the right that was recognized in Loving, that the right that was recognized in Griswold, be extended to homosexuals in the same way that it was.
What do you make of Baker versus Nelson?
Baker versus Nelson, Your Honor, first of all, was an equal protection appeal, and that's not before this court today. Second, Respondent would have Baker versus Nelson, which was a denial of a writ of certiorari, mandate this court's jurisprudence on a very integral part of substantive due process. There was no decision rendered by this court in Baker versus Nelson. And what I'm asking this court to do is actually consider the question and recognize that under its previous jurisprudence there is a fundamental due process right to marry the person of one's choosing. And finally, regarding the history and tradition, I see that I'm out of time, Your Honor. And for the foregoing reasons, Petitioner respectfully requests that this court reverse the decision of the South Virginia Supreme Court.
Thank you. The court will now stand in recess for 5 minutes pending the next set of arguments. The court is now pleased to call on Petitioner for argument.
Mr. Chief Justice Ashcroft, and may it please the court, my name is Brandon Boxler of Team B, and I represent the petitioner in this matter, Ms. Cynthia H. Mr. Chief Justice, may I please reserve 1 minute for rebuttal?
So ordered.
Thank you, Your Honor. And would the court like a brief recitation of the facts?
We'll be pleased with your decision about your argument, whatever you choose, and I'm sure the court will begin assisting you very quickly with questions.
Yes, Mr. Chief Justice. This court should reverse the Supreme Court of South Virginia for 2 primary reasons. First, the Defense of Marriage Act is inapplicable to this case because it neither directly nor indirectly preempted the PKPA. Accordingly, this case is governed by the PKPA, which plainly requires all states to enforce those sister state judicial obligations such as custody orders and visitation orders issued by their sister state courts. And second, even if DOMA did apply to the facts of this case, this court should nonetheless invalidate that statute as unconstitutional because it attempts to negate a self-executing constitutional command and because it places a substantial and unjustified burden on petitioners' fundamental right to marry. Article 4, Section 1 of the United States Constitution plainly requires that states shall give full faith and credit to the judicial determinations of sister state courts. As this court described in Baker v. GMC, this constitutional obligation is exacting. States do not have discretion to determine whether they will enforce sister state judgments.
What if Congress gives them the discretion to decide?
If Congress gives them that sort of discretion, Justice Gamble, then they would have violated the Constitution by essentially negating a clear constitutional command. In other words, the full faith and credit clause provides that states shall do something. And if Congress is trying...
Why can't we interpret the clause to say states shall do something unless Congress says otherwise?
Because the Founding Fathers did not provide that within the text of Article 4, Section 1. For instance, Your Honor, if I may compare it to Article 3, Section 2, where the Founding Fathers did provide that this court has appellate jurisdiction with such exceptions as Congress shall make. In that context, the Founding Fathers clearly wanted to give Congress the power to make exceptions to a constitutional mandate. By contrast, Article 4, Section 1 does not contain such language that would, as clearly as it does in Article 3, Section 2, provide Congress the power to make such exceptions as it deems fit. And furthermore, the two clauses in Article 4, Section 1 are joined by the word "and," which clearly indicates that the Founding Fathers indicated the two clauses to support one another, to help to define and reinforce each other's metes and bounds, not to allow one part of Article 4, Section 1 to altogether swallow or undermine the first part of Article 4, Section 1.
Wouldn't you concede that there are numerous examples of cases in which we've held that the first sentence is not absolute, that there are exceptions to the general rule, that it's not something that always has to be done, that the judgment doesn't always have to be strictly enforced?
With regards to judgments, Justice Conrad, no. But with regards to public policies and statutes of states, then absolutely. As far back...
Doesn't the PKPA itself allow states not to enforce certain custody and visitation judgments? In other words, PKPA says you must enforce judgments that are consistent with the PKPA, but you don't have to enforce any judgments that aren't consistent with the PKPA, even though they'd be perfectly valid under the law of the state in which they were entered.
Well, Petitioner would interpret that portion, and indeed the PKPA generally, as essentially clarifying the legal landscape that existed in the late 1970s. Namely, there was a lot of disagreement among state courts and indeed some district courts regarding what sort of faith and credit should be given to custody orders and visitation orders.
Doesn't that landscape, doesn't that dispute itself undercut your argument?
No, Your Honor, because under the effects clause, certainly Congress does have the power to essentially rack it up.
But it undercuts your argument that the first sentence is an inexorable command that states must enforce all judgments, all sister state judgments.
Quite to the contrary, Your Honor, because PKPA brought within the clear scope of the full faith and credit clause custody determinations and visitation orders that prior to the PKPA, it was unclear whether they fell within that scope. So in other words, Congress used its effect clause in enacting the PKPA to clarify and to reinforce the full faith and credit clause. And that's in keeping, Your Honors, with the conjunctive nature of the full faith and credit clause and the effects clause being joined by the word "and."
So the second sentence is a one-way ratchet in your understanding. In other words, it can add to the full faith and credit requirement, but it can't allow states to give full faith and credit that would otherwise be, or to refuse to give full faith and credit that would otherwise be required.
To an extent, and I would modify that slightly by saying, yes, they have the power to increase and bring within the metes and bounds of the full faith and credit clause new judgments, and even statutes for that regard. But additionally, Petitioner would direct the court to Baker v. GMC's footnote number 8, which describes other ways that Congress could use its effects power to clarify the legal landscape. For example, providing ways that district courts can validate judgments for one another. Indeed, one of the very first acts that Congress passed pursuant to its effects power was the Act of May 26, 1790, which did prescribe such procedural mechanisms such as attaching seals and whatnot, where Congress helped to clarify the metes and bounds of the full faith and credit obligations pursuant to its effects power. And again, Your Honor, that would be consistent with the conjunctive nature of the two clauses. By contrast, what the Defense of Marriage Act, if you reach that question, does is essentially create an exception to the clear constitutional self-executing command, which reaches beyond the boundaries of what's permissible under that self-executing mandate. But before...
Well, let me ask you before you go forward. A few moments ago, you used the word "the text" of the effects clause and the full faith and credit clause. So you're asking us, with regard to your full faith and credit argument, to look at the text of the Constitution. But in your substantive due process argument, you're asking us to look away from the text of the Constitution. So when do we read the words of the Constitution literally, and when do we find something implicit in the word in the Constitution?
That is a great question. It's something that this court has wrestled with for a while, Your Honor.
Well, you raised the issue and you enlightened me, so I want you to continue to enlighten me.
What I would suggest is that this court has found that some of the terms of the Constitution can be essentially broadened, which is exactly what the court has done, for example, in the substantive due process areas, by finding that essentially a lot of the guarantees that exist within the Constitution, though they may not be expressed within the text of the Constitution, cannot survive if there were not other subsequent pre-existing fundamental liberties, such as the right to marry, such as the right to privacy, which this court defined way back in Skinner and Eisenstadt and Griswold, that those sorts of liberties cannot exist in a general constitutional society, which is why, for example, this court in Palco and in...
You're telling me that liberty couldn't exist if we didn't allow people, if people weren't allowed, people couldn't use contraceptives? Or if, for instance, in the Kerry case, if minors weren't allowed to use contraceptives, I mean, or we couldn't sell contraceptives to minors?
I think to an extent, Your Honor, yes, and that's this court's jurisprudence where it is defined.
That would surprise everybody who's ever lived in Western culture from about the year 33 up until the year 1930.
Well,
and beyond, I would take it.
Well, I would direct the court again to Palco and Zablocki, where it defined fundamental rights that are inherent in the 14th and 5th Amendments as those that are inherent in the concept of ordered liberty. In other words, they must exist to some extent in order for the society to remain liberty and to remain free. But before we reach those much more difficult, complex questions, this court should seek its advice that it issued in last term under Northwest Municipal District of Austin No. 1, v. Holder, where it's essentially re-articulated the doctrine of constitutional avoidance. And that is, if this court can resolve a controversy before it without reaching those very difficult constitutional questions that you assert and ask Justice Tuskey, then it should. And indeed, Petitioner proposes that that's exactly what can happen in this case, namely that the Defense of Marriage Act and the PKPA can be resolved so as neither intrudes upon the metes and bounds of the other, and Petitioner can win under those grounds. Indeed, the legislative history of the two statutes is insightful in that regard. The PKPA was in existence whenever the Defense of Marriage Act was passed, and nothing in the Defense of Marriage Act explicitly held that it was intended to somehow intrude upon or alter the metes and bounds and the force of the PKPA. Indeed, this court in Fausto held that if Congress did intend to repeal a statute on the books, then Congress should make that intent specifically clear. It did not when it passed the Defense of Marriage Act.
So how do we read them in harmony?
We can harmonize it, Your Honor, because the Defense of Marriage Act alters or it affects those rights and privileges that arise from the marital union broadly, whereas the PKPA more specifically addresses judgments, and those are two very different things. In this case, for example, we submit that Petitioner's right to visit Mary did not arise from her marriage. Rather, it arose from a visitation order issued by the court. So to that extent,
of course, the visitation order was wrapped up in a divorce decree which ended a same-sex marriage.
That's correct. But our definition that Petitioner would submit, that this court should adopt with that arising from language, is much more restrictive in that regard. For example, that visitation order, Your Honor, in this case, did arise to some extent from the marital union. But there's nothing unique or about visitation orders generally that depend on marriage. In other words, marriage...
Without the PKPA, would states have to have recognized visitation and custody orders under the self-executing, in your term, provisions of the Full Faith and Credit Act?
That was one of the reasons why PKPA was passed to clarify that.
I understand that, but the question is not what does it do, but what would have been the effect on visitation orders without it?
Probably would be that, no, visitation orders per se would not. And that's because, as the legislative history in PKPA describes, is that visitation orders are subject to alteration and change.
What if they're embodied in a divorce decree as yours was?
To the same extent, Justice Webb, my answer would be the same, in that they are still subject to modification by returning to the court and redefining what's in the best interest of the child. So they don't have the necessary finality that might otherwise exist.
Well, if they don't have the necessary finality, why is it not a fit subject for congressional legislation?
I'm sorry, why is it?
The DOMA. Why, if they are outside the purview of the Full Faith and Credit Act without the legislation, why can't DOMA modify that without explicitly saying so?
I see. And this again would go back to some of the legislative history, which is telling in regards to the PKPA and DOMA. PKPA clarified that visitation orders are judgments for the purpose of Article 4, Section 1.
But we don't reach legislative history if the text is clear.
That's
And
correct.
what's unclear in the text of DOMA that would cause us to look at either its legislative history or the legislative history of the PKPA?
Specifically, what the words "arises from" mean within the Defense of Marriage Act. Respondent would have, it asserts that those words encompass visitation orders simply because they arise from, at some point, homosexual unions. By contrast, Petitioner asserts that visitation orders and custody determinations do not fall within the scope of those two words, arises from. And for that reason, the two statutes can be read in harmony to neither affect the other. In returning to an earlier point,
Well,
Justice
what does arise from a same-sex marriage?
Those rights that arise from, well, marriage generally, Justice Whitney, would be those that are necessarily contingent upon the marital union. For example, in 2004, the Government Accountability Office conducted a survey of just the federal code and found that there were well over 1,000 different rights and privileges that stemmed from the government recognition of marriage. So those, Petitioner would submit, are things that arise from marriage. By contrast, under Massachusetts law and other state laws, individuals can obtain visitation orders without ever entering a marital union.
But not a divorce decree. They can't obtain a divorce decree without having entered into a marriage.
That's true.
And the thing that gives effect to the visitation rights is it's being embodied in the divorce decree. Is that not correct? The divorce order, the judgment.
Justice Webb, we would draw a slightly finer distinction to that. In other words, under that interpretation, if it were to be said that essentially if you keep drilling back in the timeline from the point at which the court issued the visitation order, then anything that happened subsequent to the entrance of the marital union between petitioner and respondent would be something that arose from a union. And we think it's much more appropriate to define that in a much more limited way.
Could your client have sought enforcement of the visitation right absent the divorce decree under the PKPA?
Yes.
Would there have been a visitation right absent the divorce decree?
It's unclear from the record, but certainly there is a strong case that can be made that the answer to that would be yes, particularly because the pre-existing relationship between petitioner and respondent's daughter, Mary, in this case, preceded the Massachusetts Supreme Court's decision in Goodrich, in which allowed homosexual individuals to marry. So the foundation, and certainly some of the probate court's discussion of what would be in the best interest of the child, a lot of those reasons predate the marital union itself to find what was in the best interest. And if I may proceed to the due process argument.
The court would like to invite you to do that at this time.
Thank you, Mr. Chief Justice. In the alternative, this court does find that the Defense of Marriage Act somehow alters the PKPA, and this court should nonetheless strike it down because that interpretation would violate the fundamental right to marry which petitioner possesses pursuant to this court's jurisprudence in Loving and Zablocki. In both of those cases, this court defined the right to marry as a fundamental freedom protected by due process guarantees and found in both of those cases that substantial burdens were placed upon petitioner's fundamental right because they were excluded from being able to access that right. In Zablocki, they were excluded from being able to marry because individuals could not pay child support. Similarly, in Loving, individuals were excluded.
Of course, the sticking point here is all those cases involved marriages between men and women.
That's correct, Your Honor.
So the right we were talking about was the right of a man to marry a woman.
That's correct. But certainly prior to loving, the right that we had talked about was the right of of same-race marriage. And by contrast, and after loving, it's essentially broadened up and opened up that liberty interest, which is exactly what Petitioner seeks here. In other words, allowing individuals to access that right. And certainly that's...
What is marriage?
Marriage is certainly difficult to define, but perhaps the best expression of that came in this Court's decision in Turner versus Safley, where it said it's an expression of emotional support and public commitment that comes along with a whole host of different rights that are eloquently described in this Court's Turner opinion and Zablocki.
So there's nothing about marriage that necessarily has to do with the fact that a man is a man, a woman is a woman, and when they get together and do what men and women do, children could result.
That's correct. That's absolutely correct.
I'm trying to be delicate.
Which is why Respondent's interpretation in an attempt to limit the right to marry to somehow procreation or heterosexual unions is flawed. In particular, going back
So
to...
you're saying it has nothing to do, marriage has nothing to do with that? Marriage has nothing to do with the fact that men and women are sexually complementary and that you need a mated pair of a man and a woman to procreate?
No.
In the natural course of things.
That's exactly right. And that interpretation, that marriage does not have to deal with procreation, was consistent with this Court's interpretation of the marital right in Turner v. Safley. In that case, the Department of Corrections was trying to define or draw a fine distinction between who was able to marry and who was not able to marry based on who had children or who was pregnant. And this Court struck that down.
That definition that you just cited of marriage, wouldn't that allow anybody to marry anybody else regardless of relationship, age, whatever?
In a large way, yes, Your Honor, and it certainly allows two individuals to make that sort of emotional commitment and public commitment to one another without restraint. But in this particular context, all we're asking is for that fundamental right, if we're asking for a petitioner to be able to access that fundamental right. And consistent with this Court's jurisprudence over the years, and certainly with Lawrence overturning Bowers and Casey broadly defining the right.
What about a brother and sister?
The government, well, if there is a fundamental right to marry, and there is a substantial burden on it by excluding individuals, then it would have to satisfy strict scrutiny. And certainly, Petitioner does not argue that prohibitions on incest would fail strict scrutiny.
Why would a prohibition on incest not fail strict scrutiny?
Certainly because there are genetic concerns. There's also concerns about lack of consent in those types of relationships, undue pressures on children born to parents. I see my time is up. Mr. Chief Justice, may I briefly conclude?
I think you've concluded. Thank you.
Yes, sir.
Mr. Chief Justice, and may it please the Court, my name is Chris Healy, and I represent the Respondent, Hilda N. The Respondent respectfully asks this Court to affirm the decision of the Supreme Court of South Virginia for two principal reasons. First, the Federal Defense of Marriage Act does not violate the full faith and credit clause of Article 4 of the Federal Constitution because it merely codifies a long-recognized common law right of states not to recognize extraterritorial marriages that are in direct contradiction of a stated public policy of the forum state. And furthermore, even if this Court finds that DOMA as applied here is beyond the scope of that common law right, it is still a valid exercise of Congress's power under the Effects Clause of Article 4. And secondly, the petitioner wrongly asserts the fundamentality of a right which cannot be reasonably found within the auspices of this Court's fundamental rights jurisprudence. And therefore, they ask this Court to create essentially out of whole cloth an entirely new fundamental right for which there is no basis in the history or tradition of this country. Now, I'd like to begin by discussing the full faith and credit clause. And I think it helps to go back to its as an original matter to make a comparison between the clause that existed in the Articles of Confederation and that which existed in the nascent Constitution. And I think it's helpful to talk about the clause as it existed in the Articles of Confederation because it was only half of the clause that was imported in the Constitution. The Articles of Confederation included only the first clause. States ought to give full faith and credit to, etc. And a 1786 decision coming out of Pennsylvania, that's 3 years before the ratification of the Constitution, interpreted that clause that existed in the Articles of Confederation to extend a mandate on states, not an executionary mandate towards sister state judgments, but an evidentiary mandate, that they are required to enter into evidence the existence of sister state proceedings, but they are not required to execute those sister state proceedings. And I think it's telling that the importation of that clause into the federal Constitution did not change in a substantive way the language of the first clause, and only added to it the second clause, the effects clause, which removed a power from the states that they may have had under the Articles of Confederation and placed it in the federal Congress.
I find your argument appealing, but it seems to me the upshot of it is that the first sentence is not self-executing. And it seems to me a lot of water's already gone under the bridge on that point. We've, for a long, long time, treated the first sentence as self-executing.
Well, I would quibble with the definition of self-executing, because Congress, in the early days of immediately after the ratification of the Constitution, felt fit to enact the Full Faith and Credit Act, which essentially enacted which was implementing legislation under the effects clause to implement the broader clause as a whole. And so I don't think that it's self-executing in that it inherently commands
What about cases like Fauntleroy, all these cases in which we have held that by the force of the first sentence of the Full Faith and Credit Clause, states were required to enforce judgments?
Well, Justice Custody, I think that this case is distinguishable from those in a couple of ways. First of all, the judgment at issue with the case before the court today is not a judgment in the same sense that the judgments in Baker and Fauntleroy were. Those judgments were final judgments that could be enforced by court and essentially wash their hands of it. The judgment at issue today is a custody judgment, which, if the petitioner would have his way, would require South Virginia to continually enforce it. And that particular flavor of judgment has not been before the court today, and I would submit that it's more in line with a substantive requirement of South Virginia to recognize the substantive law of Massachusetts than it is simply an execution of a judgment, because of the ongoing nature of enforcement of that judgment. And I think it's more comparable to this court's decision in Pacific Insurance, where the basic background facts of that case were that a Massachusetts employee employed by a Massachusetts corporation traveled to California and was injured in the line of his work. And this court held that California was under no duty to apply the substantive workers' compensation law of Massachusetts. Now, I recognize that court didn't involve a judgment, but I think the upshot of that court, of that decision, was that where full faith and credit would alter the judicial proceedings, ongoing judicial proceedings of the forum state, such that it would conflict with their public policy, they're not required to honor that. And I think that the judgment at issue before the court today cuts more in that direction, because of the ongoing enforcement that South Virginia would have to engage in order to honor it to the extent that the petitioner asked.
Are sister state injunctions generally enforceable?
Well, I think that you're referring to Baker against GMC, and I think that case had more to do with issue and claim preclusion as general issues of comity between the states. But I also think that it's important to know that the injunction that was attached to the former GMC employee in that case did not travel outside of a claim between the two parties. And so it acted as a final judgment as it related to
Actually, my question is more general. Are injunctions generally required to be enforced? Sister state injunctions generally required to be enforced. Let me give a hypothetical. Suppose that I was ordered by a court to turn over a valuable piece of art to the plaintiff, and I've vamoosed to another state. And he follows me to the other state, seeks enforcement of the injunction he had received in the first state. Would the full faith and credit clause require the enforcement of that injunction?
Well, I think so, Your Honor, and Justice Tusky, and I think the reason is that enforcement of that court order would be a discrete act, and it doesn't, as Fauntleroy said, it wouldn't necessarily imply that the forum state, assuming that for purposes of argumentation, that the underlying claim regarding that piece of art assumed that it would not have been bringable, it would not have been substantively recognized in the forum state. The forum state would still be required under principles of full faith and credit to honor it, because they would not be lending sort of tacit approval to the forum, to the original issuing state's substantive law. But I think that differs in kind from the issue before the court today. Because
is the DOMA a general law, since it's aimed at a narrow class of persons?
Are you referring to general law within the meaning of the effects clause?
That's correct.
Yes, I think so. And I think the proper mode of analysis to determine what that term means in the context of the effects clause can be seen by a comparison with the prohibition on bills of attainder elsewhere contained in Article 1. Now, the prohibition on bills of attainder prevents Congress from singling out individuals and labeling them violators of the law. And I think that the best interpretation of the general law requirement inside the effects clause is that it precludes Congress from identifying particular states whose judgments need not be given full faith and credit. So, for example, Congress under that reading would not be allowed to pick South Virginia and say to the other 49 states that the judgments, acts, proceedings coming out of South Virginia need not be given full faith and credit. And I think that's the more consistent reading compared to other terms in the Constitution than to say that the general law does not refers to a specific class of judgments. And I think that's the more consistent reading, Your Honor.
What do you have to say about opposing counsel's assertion that what we really have here are two competing acts of Congress, and that they can be read harmoniously, they can be read so as to be consistent with one another, and therefore the requirements of DOMA don't necessarily overcome the requirements of the PKPA?
Well, Justice Conrad, I would say that particularly in this case, the custody order at issue, our position is that it is inextricably linked and certainly for purposes of DOMA arises out of the same-sex marriage in Massachusetts. So to the extent that a judgment or a right or a claim arises out of a same-sex marriage, in this case it's a custody judgment, we would say that it conflicts with the PKPA, and so that DOMA preempts that. And this court would be following terms of statutory interpretation to enforce the Defense of Marriage Act as it relates to this judgment rather than the PKPA.
Does DOMA mention visitation orders? It really is limited in its terms to the relationship of two people, not to a child who may have been associated with that union.
Well, with respect, Justice Conrad, I disagree. I think that the terms towards the rights associated with visiting a child would certainly be included within the rights arising out of a same-sex marriage, because in this case, Cynthia had no relationship with Mary prior to the marriage, and she never formally adopted her. She has no biological relationship to her. And indeed, in the eyes of the law, she has no parental relationship towards Mary whatsoever. The only relationship is contained in the divorce decree, and it's a judgment requiring visitation. And additionally, our position is that for purposes of full faith and credit, it's not a final judgment, because under Thompson versus Thompson, this court held that for purposes of full faith and credit, because they are subject to continuing review at the trial court level, custody judgments are not final judgments within that meaning. And additionally, this court held in Thompson that the issuing state, the forum state in which the custody judgment is sought to be enforced has exactly the same authority to modify the judgment as the issuing state. So the Circuit Court of Queens County in South Virginia has the same jurisdiction and authority to adjust the terms of the custody agreement on its merits than the probate court in Massachusetts, and that would be consistent with this court's holding in Thompson. Now, additionally,
that is unless the PKPA applies.
Oh, yes, but it's our position that that doesn't, because DOMA, because the right arising here, the custody right, clearly arises out of a same-sex marriage, which DOMA speaks to directly. It is a right arising out of it. This custody judgment would never have existed absent the marriage, and so it arises out, and DOMA does speak directly to it. We would not say that DOMA as a class in a sort of wholesale way preempts the PKPA, but as applied here it does, because this custody judgment arises out of the same-sex marriage.
Wasn't the PKPA amended after DOMA was enacted?
That's true, Your Honor, but I don't think it amended the specific provision at issue here.
But didn't Congress have the opportunity to address the DOMA issue and chose not to.
Well, I actually think that cuts the other way, Your Honor, Justice Whitney, because I think if they felt the need to adjust it, they would have had the opportunity to clarify that DOMA doesn't apply, and they didn't do that. So I think now, to the extent that legislative history delving into that is even necessary in the case before the court today, I still think it cuts in our favor. Now, as towards the substantive due process argument, Petitioner seeks to have this court read into the fundamental rights jurisprudence, the corpus of law that this court has laid down, an implicit right to same-sex marriage. And it's our position that no reasonable reading of this court's fundamental rights jurisprudence can possibly find within those cases a right to same-sex marriage. Petitioner relies heavily on Loving, on Zablocki, and on Turner, and I'll address those cases seriatim. First of all, Loving is overwhelmingly an equal protection case. That case is about the fundamental injustice that applies when the government passes a law that facially discriminates on the basis of the color of a person's skin. In that sense, it is the paradigm equal protection case. The fundamental rights language in Loving is an afterthought. It is 2 paragraphs tagged on at the end, and it's our position that it is there really more to highlight the odious nature of the racial classification at issue in that case. And the language in Loving related to a fundamental right of marriage is really more in the context of the marital relationship's foundational role in society as the sort of threshold relationship before the bearing and begetting of children and the raising of children. So it's our contention that even on the explicit terms of Loving, it's not considering same-sex marriage. And if you look at the case in its broader societal context and in the circumstances in which it arose, I think it's clear that same-sex marriage was not contemplated by that case. And it would be the same issue with Zablocki. Zablocki applied the fundamental right to marriage to a father who was behind.
What is marriage?
Well, I think that...
Actually, let me ask 2 questions here.
Certainly, Your Honor.
What do you say marriage is, and what do our precedents say marriage is and the value of marriage is?
Well, I'll address the precedents first. And I think that this Court's precedents firmly recognize that, at least for the purposes of the Due Process Clause, marriage has consistently been recognized as that between a man and a woman.
Why should marriage be recognized as simply that between a man and a woman?
Well, as a moral judgment, I'm not really... I don't think that that's actually necessary, but I do think that the definition of marriage for purposes of legal rights should be left to the several states and let them determine that through the legislative process. Because as this Court has recognized in other areas, particularly the Eighth Amendment, there are evolving standards that societies change and have different opinions and different conceptions of what rights may exist as our forefathers did.
Because the point of my question is this: if there's nothing about marriage, if there's nothing about the nature of marriage that makes it by its nature something that can only be entered into by a man and a woman, that's simply just a definition that we've come up with, and that marriage really is something that two men or 2 women who love each other can enter into every bit as much as a man and a woman, aren't we denying a fundamental liberty based on no rational basis?
Well, I don't think so, Justice Tusky, and I think the reason for that is partially contained in this Court's precedents because it's consistently recognized the right of marriage only in the context of a man and a woman. But I think that on a broader level, to define it in a different way would be sort of a revolutionary and fundamental change to what has been pretty consistently recognized as a dual-gender institution for as long as our country has been around. And if the Court seeks
But I think that's the import of Loving. I mean, for years and years and years, we had at least many states in this nation had recognized marriage between a black man and a white woman or a white man and a black woman as something that, as the Virginia Supreme Court said, was ordained, was forbidden by Almighty God. It's just something that just wasn't possible.
Well, Justice Tusky, I think that the thrust of Loving is really the Equal Protection Clause. And whatever the traditional definition of that institution in that context had been prior to Loving, the passing of the 14th Amendment and the Equal Protection Clause mandated a change in that definition because we no longer believe that facial classifications based on race that cannot be said to pursue a compelling government interest by the least restrictive means are invalid. But furthermore, to get back to some of what your questions on other examinations have hinted at, is that those unions, however they may have been looked down upon, were still recognized as marriages. And I think that this society has consistently shown that the definition of marriage, at least in terms of the United States body politic, is that between a man and a woman. And I think that only in the
If
last...
that's just a societal convention, rather than anything inherent to the nature of relationships between men and women, why should we exclude from the protections of that relationship other couples?
Well, in the context of fundamental rights, I think that it is the societal convention, at least that plays a role in the determination of what that fundamental right is. And because I submit to the court that the right of same-sex marriage is not inextricably or rationally contained within this court's other substantive due process jurisprudence, what the petitioner is asking this court to do.
What do you make of our definition of marriage in Eisenstadt versus Baird as an association of two individuals, and our statements about marriage in Turner versus Safley, which seem to imply that marriage is really just about the companionship, the loving companionship, and all of that between two people?
Well, Justice Tuskey, to address Turner versus Safley first, I believe the language in Turner explicitly extended the right that was established in Zablocki to prison inmates. And it's our contention that the right established in Zablocki was contingent on the heterosexual relationship.
But is it not the case that it was likely, if not inevitable, that the marriage in Turner was not going to be consummated?
Well, in a broader sense, in terms of inmates as a class, many inmates are going to get out of jail at some point, and so if the state's justification is...
But that particular inmate?
Well, I think that still, in terms of a societal definition of marriage, it's not hinged on procreation, but hinged more on tradition, and the traditional relationship of a man and a woman as being that relationship which is the foundational relationship in the most basic building block of society.
What about our language in the last paragraph of Lawrence, which doesn't seem too kind to tradition? At least traditions that we see as impinging on people's people's liberties.
Well, I think that the language in Lawrence actually highlights what the distinction that the respondent comes before the court to make today, and that there's essentially two paths to fundamentality under the Due Process Clause. Either there's the Glucksberg history and tradition test, or there is this court may use reasoned judgment to find a right that's not so much being recognized for the first time before the court today, but is implicitly included in the prior due process jurisprudence of the court.
He wants you to read Zablocki and Lawrence in tandem and conclude that the right to privacy encompasses the right to a same-gender marriage.
Well, I think that there's a difference in kind between the right asserted in Lawrence and the right asserted before the court today. Lawrence was about a criminal sanction imposed on people because of conduct that was engaged in behind closed doors, and the right recognized in Lawrence was a general right that this country has recognized for some time, that conduct which does not create a negative externality on other individuals and which goes on in private is generally implied to be encompassed within this court's definition of the right of privacy. But the right asserted today requires an affirmative recognition by the state, an affirmative grant of approval by the state upon, yes, Your Honor? Oh, excuse me. Affirmative grant of approval upon this relationship that the state has never intimated it would engage in prior to today. And that's why we think that, yes, Your Honor?
Well, a moment ago you said we define marriage based on tradition. How long does it take for same-sex marriage to become a tradition?
Well, I think that in terms of fundamental rights jurisprudence, there would have to be a gradual... I see I'm out of time. May I continue?
Yes, you may, but try to be careful about how much time you spend.
Well, certainly. I think that, Justice Whitney, the determination of how long the right has been around for purposes of the Glucksberg history and tradition test is something that, frankly, this court has never determined. This court has never said precisely how long that tradition is. But I would submit to the court that 10 years of sporadic legislative and judicial fiat across this country in a handful of states, whereas a vast majority of states have affirmatively gone in the other direction, certainly does not qualify as a history and tradition. Thank you.
Thank you. You may proceed.
Thank you, Mr. Chief Justice. At bottom, this case is about whether South Virginia must enforce a validly issued judgment by the state of Massachusetts? The answer under the full faith and credit clause and under the PKPA is yes. The Defense of Marriage Act does not apply to this case, and this court need not reach the very complicated constitutional questions that it could reach if it decided that somehow the Defense of Marriage Act superseded either directly or indirectly portions of the PKPA.
Counsel, you had stated earlier that same-sex couples have a fundamental right to marry. What effect should we give our dismissal of the question presented in Baker versus Nelson, and I quote, that whether the denial of same-sex marriage deprives appellant of their liberty to marry without due process of law under the 14th Amendment?
A few points on Baker v. Nelson quickly. First is that it was a one-sentence dismissal that did not have the full benefit of briefing or oral arguments by the parties. If I may briefly respond, Mr. Chief Justice. And I would also say that the history, as this court described in United States versus Virginia, the history of this court's constitutional jurisprudence under the Due Process Clause has been the extension of constitutional rights and liberties to parties who had previously been excluded from access to those rights. This case, you should extend that right to marry to petitioner. So for that reason, we ask you reverse the judgment below. Thank you, Your Honor.
The court at this time would want to thank the participants, and we will deliberate regarding this matter for a few moments, and we will invite you then back for some comments. So the court is prepared to dismiss you now at this time and invite you to come back in about 5 minutes. Thank you.